Okay, so here we are again. We're here to research Amy Coney Barrett. Again, this segment is meant to be. I have the not the debate, the election going on this screen, so maybe I should put that down for the next hour. But we're going to be continuing our research on Amy Coney Barrett. This is an attempt for me to become more knowledgeable in the ways of politics and understand the people who are being elected and brought into office, regardless of what office that is. So in this case, Amy Coney Barrett is a associate justice of the Supreme Court of the United States. She previously served as a circuit judge on the United States Court of Appeals for the Seventh Court. She has a background in statute interpretation and has served as a law clerk for both the circuit and Supreme Courts. Last time we learned that the hierarchy of court system in the United States is Supreme Court, followed by the appeals court, followed by a district court. So if you go to a district court for some crime that you've done, you're found guilty, you can appeal to the circuit courts or the courts of appeals. And if you are still unsatisfied with the ruling of that court, you can appeal to the Supreme Court and see what they say. And for context of who we are researching, Amy Coney Barrett, she is sitting in the highest court, and she's 48 years old. She's got 7 kids. She was brought into the courts of appeals by President Trump in 2017, and she was brought up to the Supreme Court by Trump this year in 2020. With all that being said, let's go ahead and begin our research. Amy Coney Barrett. Okay, so last time we were kind of in the wiki, and also last time I realized this, and I'm really sorry for it. I did not have a really good screen resolution set for the recording. The recording is still important to get you to this point, and so if you need to play catch up, which most of you, if you're watching part 2, are going to need to watch part 1, you don't have to watch. I think that I spoke enough during the thing to make it listenable, so give it a listen in the car or wherever it is that you can listen to things, and get the background for this. Essentially all we went through is like a massive background of how the hell the Americas work for the court systems, and how laws come in by a legislative body, and that courts and trials are actually just the interpretation of the law that was brought in by the legislature and not the actual bringing of a law. So courts don't bring forth legislation, they just interpret the legislation that has already been brought forth. We have some definitions up in the right hand there that we brought down from last time, and we also have this little section called future research questions, and these are really important questions. So I want to know what the usual background for a Supreme Court judge is, because Amy Coney Barrett is 48 years old. She has 7 kids. It sounds like she has a really, really busy life. But she also wasn't in any judgment position until 2017, and then she's in the highest court this year. That seems really fast to make it to that point. So I kind of want to research some of the other judges in the Supreme Court currently. I'd also like to research some of her previous cases and articles, just to kind of get a feel for who she is and what she has decided in the past. And actually, when we talk about cases, we only really have from 2017, and who knows how many she got through during that time from 2017 to 2020, only 3 years of time. Then again, she is in a court system that is representing many district courts, so I'm sure there's plenty of opportunity for cases at that level. But it would be interesting to see what she found. I'd also like to research her involvement in Bush versus Gore, because apparently she was a part of the firm that represented Bush during that trial. So I'd be interested in that. we should probably start verifying our information somewhere else other than just Wikipedia. Wikipedia is pretty cool because we were able to dive in to some pretty deep stuff really quickly last time, but we should probably verify our information to make sure that there's no hidden agenda inside of this article. And finally, how does she balance her life? How does she do that? She's a Supreme Court judge. She's a part of the highest court in the United States. She has 7 kids. I'm curious how she is managed because she looks healthy. And it sounds like she has a really healthy career too. So with all that being said, let's go ahead and get started with the new research. So I know the first question is, what is the usual background for the Supreme Court judge? But I'm actually really, really, really interested in these selected cases. So on the 7th Circuit, Barrett wrote 79 majority opinions, including 2 that were amended and 1 that was withdrawn on rehearing. For concurring opinions, 4 concurring opinions, and 6 dissenting opinions. So she had 6 published and 1 in an unpublished order. Let's look at some of these. Title IX of the Education Amendments of 1972. In June 2019, the court, in a unanimous decision written by Barrett, reinstated a suit brought by a male Purdue University student, John Doe, who had been found guilty of sexual assault by Purdue University, which resulted in a 1-year suspension, loss of Navy ROTC scholarship, and expulsion from the ROTC, affecting his ability to pursue his chosen career in the Navy. That's problematic. He had been found guilty of sexual assault. That's even more problematic. Doe alleged the school's advisory committee on equity discriminated against him. John Doe alleged the school's advisory committee on equity discriminated against him on the basis of his sex and violated his rights to due process by not interviewing the alleged victim, not allowing him to present evidence in his defense, including an erroneous statement that he confessed to some of the alleged assault, and appearing to believe the victim instead of the accused without hearing from either party or having even read the investigation report. The court found that Doe had adequately alleged that the university deprived him of his occupational liberty without due process in violation of the 14th Amendment and had violated his Title IX rights by imposing a punishment infected by sex bias. And remanded to the district court for further proceedings. Interesting. Okay, so guy, John Doe, gets accused of sexual assault. He gets punished and loses his ROTC scholarship and prevented him from pursuing his career in the Navy. That all seems pretty big. And it sounds like they didn't... Can we find the... It sounds like they didn't hear from either of the 2. How do we search for this? I want to know. Doe versus Purdue University. It sounds like it, huh? Wow. That was nice. Okay, Google Scholar. It's a direct... Okay. So let's see if we can get anything out of this. After finding John Doe guilty of sexual violence against Jane Doe, they're related. Just kidding. Purdue University suspended him for an academic year and imposed conditions on his readmission. As a result of that decision, John was expelled from the Navy ROTC program. That sucks, which terminated both his ROTC scholarship and planned to pursue a career in the Navy. So this is one example of... Let me give an example, I should say, of how this could be used in an argument for either side, Republican or Democrat, right? Like we talk about these bipartisan issues, and I feel like this could easily be used as like a bipartisan issue for both sides. On one side, you've got a Democrat who could possibly use this as like Well, actually, I'm not going to go into any of that. John sued the university and several of its officials, asserting two basic claims. First, he argued that they had violated the 14th Amendment by using constitutionally flawed procedures to determine his guilt or innocence. Second, he argued that Purdue had violated Title IX by imposing a punishment infected by sex bias. Okay, so Title IX. Let's look this thing up. Again, this entire thing is based on my ignorance. I don't know these things. Title IX is a federal civil rights law in the United States of America that was passed as part of Education Amendments of 1972. This public law... Okay. Titles amended. They amended the education title. Enacted by the 92nd States Congress. Statutes at Large 86 Stat 235. Nicknames. Education Amendments of 1972. Oh, look at that title. That's the long title. Title IX is a federal civil rights. Yeah, so, okay. Title IX of the Educations. Okay. The United States Department of Justice. This could be a site. This could be a site that we enjoy looking at, huh? We could definitely enjoy looking at this site. On June 23rd, 1972, the President signed Title IX of the Education Amendments of 1972 into law. Title IX is a comprehensive federal law that prohibits discrimination on the basis of sex in any federally funded education program or activity. The principal objective of Title IX is to avoid the use of federal money to support sex discrimination in education programs and to provide individual citizens effective protection against those practices. Title IX applies, with a few specific exceptions, to all aspects of federally funded education programs or activities. In addition to traditional educational institutions such as colleges, universities, and elementary and secondary schools, Title IX also applies to any education or training program operated by a recipient of federal financial assistance. The Department of Education issued regulations on the requirement of Title IX in 2000. A Title IX Common Rule published on August 30th, 2000 covers education program providers, recipients that are funded by other federal agencies. Okay, so he was claiming that this was based on sex, that they automatically claimed he was guilty, or that, right? Is that what they're getting at here? Vital, yeah. Without due process of the 14th Amendment, so let's look at that. The 14th Amendment of the United States Constitution was adopted July 9th, 1868, as one of the Reconstruction Amendments, arguably one of the most consequential amendments. It addresses citizenship rights and equal protection under the law and was proposed in response to issues related to former slaves following the American Civil War. And was proposed in response to issues related to former slaves. Okay. So this is in a context of slavery. So we're using the 14th Amendment, which was written in the context of slavery for this case as well. Interesting. Okay. The amendment was bitterly contested, particularly by the states of the defeated Confederacy, which were forced to ratify it in order to regain representation in Congress. The amendment, particularly its first section, is one of the most litigated parts of the Constitution, forming the basis for landmark Supreme Court decisions such as Brown v. Board of Education regarding racial segregation, Roe v. Wade regarding abortion, Bush v. Gore regarding the 2000 presidential election, and Obergefell v. Hodges regarding same-sex marriage. Okay, so it's interesting. Bush v. Gore, Amy Coney Barret was a part of that. She may not have been an attorney, or she may not have been the judge, but she was definitely representing Bush in this Supreme Court decision. Anyways, so it's interesting. She's got a background in this, and that the fact that she has a background on the 14th Amendment probably helped her in this. court found that Doe had adequately alleged that the university deprived him of his occupational liberty without due process. His occupational liberty. Okay, let's look at this 14th Amendment again. I want to read the actual amendment. I don't want to hear about its background. So let's find it. Privileges, due process clause. Due process deals with the administration of justice, and thus the due process clause acts as a safeguard from arbitrary denial of life, liberty, or property by the government outside the sanction of law. Okay. Due process of law in the 14th Amendment refers to the law of the land in each state, which derives its authority from the inherent and reserved powers of the state, exerted within the limits of those fundamental principles of liberty and justice which lie at the base of our civil and political institutions, and the greatest security for which resides in the right of the people to make their own laws and alter them at their pleasure. Okay, let's return to the context. Man. Okay, we need to figure out a process for looking at court cases. Mostly because I want to know the arguments for both sides, and I want to know the facts of the situation from both sides. Not the facts. I want to know the telling of the tale from both sides. But okay, so we can say, at least in this case, Title IX, in this case, she sided on the side of the male. The court found that Doe had adequately alleged that the university... In June 2019, the court, in a unanimous decision written by Barrett, reinstated a suit brought by a male. Okay, so essentially the suit had been put to rest, and they brought it back. I wonder why. Okay. Anyways. Okay, we can say that she brought justice to a case that had already been put to rest. We'll say Purdue Joe. And what does this show us about her? Okay, so that shows, one, that she's not lazy and she's willing to find justice even in the past. What is that? Like, willing to bringing justice after ruling. I wonder what that, like, is there a good leaders facing justice, the role of international court, criminal court, how the court works? No, none of these are for me. So let's say, what was the name of that? There was a certain word. Reinstate a suit. I'm sure that there's language surrounding that. Suit reinstated. Reinstatement of civil suit. Uganda Legal Information Institute. Okay. The application instituted a civil suit against... Nope. That's specific. Texas cheerleader suit on religious banners is reinstated. I guess we're just going to say reinstated. Grounds for reinstatement. How to retain or reinstate a case dismissed by the court. Okay. There's got to be a word in here that I could use. If nothing happens in your case for a while, it can be dismissed for want of prosecution. The article tells you how retain, keep your case open, or reinstate, reopen your case if it has already been dismissed. Wait, if nothing happens in your case for a while, it can be dismissed for want of prosecution? DWAP? Is that only in Texas? Jesus, that's terrible. So we got justice just being thrown out the window here. That's horrible. That sucks. Reinstatement of parental rights, Rule 25. She's willing to find out justice for those in facing wrong conviction in the past. Okay. I wonder who brought that to her attention, though. Because it sounds like she actually was the writer of that. Okay, employment discrimination. In 2017, what else does that bring for her? Willing to find justice for those facing wrong conviction in the past. Yeah, we'll leave it at that for that one. In 2017, the Seventh Circuit rejected the federal government's appeal in the civil lawsuit against AutoZone. The Equal Employment Opportunity Commission argued that AutoZone's assignment of employees to different stores based on race, sending African American employees to stores in heavily African American neighborhoods, violated Title VII of the Civil Rights Act. That's interesting, that AutoZone's assignment of employees to different stores based on race. Okay. Violated the Title VII. Following this, Barrett joined the court as it received a petition for hearing en banc. Let's look that up. I'm middle clicking here. That means go into the new tab. In law, en banc session, or in bench, is a session in which a case is heard before all the judges of a court, before the entire bench, rather than by one judge or a panel of judges selected from them. Interesting. What is the bank? Is that like every judge that is in that court? Yeah, so the Supreme Court hears all their cases en banc. Appellate courts in the United States sometimes grant rehearing en banc to reconsider a decision of a panel of the court, typically consisting of only 3 judges, in which the case concerns a matter of exceptional public importance, or the panel's decision appears to conflict with a prior decision of the court. Who are these judges, though? Like, are we talking the circuit? Anyways, okay, we know what en banc is now. Suit. AutoZone. Following this, Barrett joined the court as it received a petition for rehearing en banc. 3 judges, Chief Judge Diane Wood, I hope that's a female, yeah, Diane, and Judges Ayanna Rover and David Hamilton voted to grant rehearing and criticized the 3-judge panel's opinion as upholding separate but equal arrangement. Barrett did not join the panel opinion, but voted with 4 judges to deny the petition to rehear the case. The petition was unsuccessful by a 5-3 decision. In 2019, Barrett wrote the unanimous 3-judge panel opinion affirming summary judgment in the case of Smith versus Illinois Department of Transportation. Smith was a black employee who claimed racial discrimination upon his dismissal by the department, and that he was called by a black supervisor. The department claims Smith failed work level expectations during probationary periods. Barrett wrote that the usage of the racial slur was egregious, but Smith's testimony showed no evidence that his subjective experience of the workplace changed because of the slur, nor did it change the department's fact that his discharge was related to poor performance. Okay, so let's summarize that. Let's say that employment discrimination. She cited that it was fair. This seems weird though. This seems weird for a lot of reasons. So it sounds like we got a guy who got called a racial slur, and was he upset because he was in an area with... Was he upset because his supervisor was black and he didn't want to be in that area, but AutoZone was forcing him to be? This is a weird case. That sucks though. All right, let's look at 63. This guy. Yeah. Word. Can we click that and go to it? No. Okay. Let's look this guy up. Let's do some reading. What are we at? 26 minutes. Okay, we got time. I want to learn about this for real. Okay. Judgment against AutoZone affirmed in EEOC disability discrimination case. Chicago. The U.S. Courts of Appeals for the 7th Circuit has affirmed a $424,000 judgment, including $9,000 in costs against AutoZone, Inc. for violating the Americans in Disabilities Act, ADA, and U.S. Equal Employment Opportunity Commission announced today. Okay. The decision also upholds an injunction requiring the National Auto Parts Retailer to provide reasonable accommodations to employees with physical disabilities in all of the stores in Central Illinois. Okay, so I feel like this Wikipedia article is a little weird. Is this Smith versus Illinois? Smith was a black employee. Okay, hold on. Are these two different things? Separate but equal arrangement. Barrett did not join the panel opinion but voted with 4 judges the petition. In 2019, Barrett wrote the unanimous 3-judge panel opinion affirming summary judgment in the case of Smith versus Illinois. This isn't Smith versus Illinois though, is it? Okay, let's look up Smith versus Illinois and see if this is the same thing. I'm confused because the Wikipedia article's headings aren't seeming to line up. Smith versus Illinois. During his probationary employment period, Smith challenged and failed to follow directions as the confrontational engaged in unsafe conduct. Was confrontational, engaged in unsafe conduct, and received unsatisfactory evaluations. He filed internal and union complaints alleging abusive language, docking his hours, and racial discrimination. The Illinois Department of Transportation discharged Smith. Smith sued the department under Title VII, arguing that it had subjected him to a hostile work environment and fired him in retaliation for his complaints about racial discrimination. The district court granted department summary judgment. 7th court affirmed. Okay, I'm still not seeing anything with AutoZone here. Smith began working as an emergency traffic patrol. Yeah, so this is a different case. Okay. So we've got the AutoZone case, and we've got okay. I want to see Terry L. Smith versus Illinois Department of Transportation. Okay. So this is the actual thing. I love this, like, Oh, this font is just awesome. And like the orderliness of this paper, like wow, so cool. Okay, we're gonna open that in another thing, and let's go back up. I guess we could just use that link to go back up, and let's open up this one. Profile of a potential nominee. Okay, so that's, oh man, that doesn't have a clickable. Let's go back up to it then. So, okay, 2 different cases. Boom, figured it out. We're awesome. We should probably actually put in like a thing for that. I'm gonna put that in my notes. So I know that this is unrelated to the video, but hey, we're here. We might as well write it down. Okay, 1 is under selected cases. Was it Smith versus Illinois? Okay, so we've got that, and we can go up here. Now that we have that figured out, let's think about these things. So she's got employment discrimination. What did they? Okay, she voted against. She did not join the panel opinion, but voted with 4 judges to deny the petition to rehear the case. The petition was unsuccessfully 5-3 decision. So let's look into this and see what the claims were, because I'm actually interested in that. So this is Smith versus Illinois, but what we're interested in is the AutoZone one right now. Yeah, this guy. Okay, hopefully that actually did copy, even though the tooltip left. It did not copy. Dang it. Okay, EEOC versus AutoZone. Hopefully that's enough. It looks like it was. I want to know. I want to see the actual thing though. I don't want to see. There we go. All right, let's make sure this is the right one. 153201. I don't know if that's the right one. 15301. Is that not what we look at for these things? I'm ignorant to knowing whether or not I'm looking at the right case. I don't. This seems like the right one. Like, how many times has the EEOC sued AutoZone? If it's multiple times, I don't want to be going to AutoZone. Appeal from the United States District Court for the Northern District of Illinois, Eastern Division. Okay. And does... Oh, we're just trying to figure out what the case is about. I'm gonna copy this because I wanna make sure that we're looking at the right one. I'm pretty sure we're looking at the right one, but I want to be sure. Again, if AutoZone's getting sued by EEOC all the time, that would be problematic. Eh? And again, I said this yesterday, or not yesterday, but the last time we did one of these videos, and the last time we did part one of this series, I said that we're not looking for things to like slanderize her or anything like that. We actually want to know who she is and what her character is. And I know that the people who chose her probably did this too, but it's kind of nice to get your own feel for it, right? So like we're doing some pretty crazy backstory on this. We don't care about the Seventh Circuit thing. I think that's just for the... I want to see the paper. See, like, oh, why can't we just get this? Okay, so we were wrong. That wasn't the right one. Oh, this is Keith Ward versus AutoZoners. Those AutoZoners. This was 2013. Is this the same one? No, 2017. AutoZone's all over the place with this stuff. It's crazy. Looks like other people are searching this too. There we go. That's what I'm looking for. 153201. Is that what we were looking at earlier? I think it is. This stuff looks all the same. Okay. Anyways, Sykes, circuit judge from 2008 to 2012. Kevin Stuckey worked as a sales manager for the auto parts retailer AutoZone, Inc. During his 4 years with the company, Stuckey was transferred between Chicago area stores several times. None of these transfers entailed any loss in pay, benefits, or job responsibilities. In July 2012, he was transferred again, this time from a store on Kedzie Avenue that serves a largely Hispanic clientele. This transfer, too, involved no reduction in his pay or responsibilities. Stuckey never reported for work at his new assignment. Instead, he filed a complaint with the Equal Opportunity Commission, accusing AutoZone of a racial discrimination in violation of Title VII. Stuckey is black. He claimed that AutoZone transferred him out of the Kedzie location in an effort to make it a predominantly Hispanic store. Oh my gosh. Why do I react that way? The EEOC filed suit on Stuckey's behalf, alleging that the transfer violated 42 USC 2000E-2A2, an infrequently litigated provision in Title VII that makes it unlawful for an employer to limit, segregate, or classify his employees in any way which would deprive or tend to deprive an individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. Let's read that again. To limit, segregate, or classify his employees in any way which would deprive or tend to deprive an individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. So from that, we can say that we can ask, was he deprived of employment opportunities? Or did this adversely affect his status as an employee? The district judge granted summary judgment for AutoZone, holding that the transfer was not an adverse employment action. The EEOC contests this conclusion, arguing that the statute does not require the claimant to prove that the challenged action adversely affected his employment opportunities or status. That reading cannot be squared with the plain statutory text. We affirm. Okay. So essentially, he's taking Title VII. He's taking Title VII, and he's saying that I don't have to prove that it adversely affected me, which is true. Wow, there's a lot of background. It'd be actually pretty fun to go through court cases and discuss it. And so she cited with what? She sided with okay. So she cited that they wouldn't rehear the case. What does that mean, though? Did they find did they find AutoZone guilty of that? I want to know. I want to know. Annotation. What did they rule on this? She voted against rehearing it. So if it had to be reheard, and it was who that was trying to get it reheard? Three judges chief voted to grant rehearing and criticized the three-judge panel's opinion as upholding separate but equal arrangement. Barrett did not join the panel opinion, but voted with four judges to deny the petition to rehear the case. The Seventh Circuit rejected the federal government's appeal in a civil lawsuit against AutoZone. Okay. So it was rejected. They wanted it reheard, and she voted against rehearing it. Okay. I'm not sure what we can conclude from that. I don't want to make any leaping conclusions. Yeah, I don't want to make any leaping conclusions. So she voted against I'm going to say it's problematic, but also that I don't have the full background. And that we should probably revisit. There's a lot of background surrounding that, and it sounds like, man, okay, I see where people sit. Like, if you make any kind of comment on this, this could be problematic, and I can see how people would get mad about it. I can really see how people get mad at it. So if I say anything offensive or something that you disagree with, please bring it up to me, and bring it up in like try not to get angry with me. Like, I'm trying to learn here, right? So basically I'm doing my best, and if I'm learning how to walk, for instance, and my legs are shaky and I hit my head or I push over a cup of water, don't hurt me because of it. But it sounds to me like this guy was getting tired of getting transferred everywhere. And although it didn't, it didn't appear from the outside, from the records that AutoZone was keeping, that his job status or responsibilities or money were being affected. But you still, you can't, I feel like it's almost a leaping conclusion that they were moving him around because of the race of the store. But at the same time, being transferred from store to store would suck. That would really suck, especially if it's in different parts of town. I don't know the geolocation of these stores, but that would suck to be transferred constantly and not know where you're going to go to work. But to make it a racial claim, that's a little leapy. Maybe he heard something. Okay. Oh, I see. Okay, there's not a heading difference here. These two paragraphs are related because they're both employment discrimination. Duh. Okay, Smith versus Illinois Department of Transportation. Smith was a black employee who claimed racial discrimination upon his dismissal of the department, and that he was called bad things by a black supervisor. The department claimed that Smith failed work level expectations during probationary periods. Barrett wrote that usage of the racial slur was egregious, but Smith's testimony showed no evidence that his subjective experience of the workplace changed because of the slur, nor did it change the department's fact that his discharge was related to poor performance. Okay, let's look at the actual case. Terry L. Smith, defendant, Illinois Department of Transportation. Barrett, circuit judge. After a rocky probationary... Is that the announcement of who's typing this? After a rocky probationary period, the Illinois Department of Transportation discharged its employee Terry Smith. Smith sued the department under Title VII, arguing that it had subjected him to a hostile work environment and fired him in retaliation for his complaints about racial discrimination. The district court granted summary judgment to the department on both claims, and Smith insists that it was wrong to do so. He contends that the district court mistakenly concluded that testimony from two of his witnesses was inadmissible and that he has enough evidence to make it to a jury in any event. We disagree and affirm this district court. And affirm the district court. Okay. So he's trying to make a claim. Smith sued the department under Title VII, arguing that it had subjected him to a hostile work environment and fired him in retaliation for his complaints about racial discrimination. So that sentence is the kind of damning one. That essentially everything was fine. Well, possibly not. There's a possibility that the work environment was actually pretty hostile, even pre this event, and those events kind of stacked up into this event and eventually called for him, saying that there were discrimination complaints. He contends that the district court mistakenly concluded that testimony from two of his witnesses was inadmissible. I'm going to look up the definition of this word real quick. I am pretty sure I know the definition, but I just want to make sure. Not accepted as valid. Yep. Okay. From two of his witnesses, that testimony from two of his witnesses was inadmissible, and that he has enough evidence to make it to a jury in any event. So basically, interesting. They're blocking it. That's essentially what's happening here. Smith began working as an emergency traffic patrol Minuteman with the department late in 2013. Minutemen perform various duties related to traffic and roadways. Smith's employment began with a probationary period starting August 1. To be certified, he had to successfully complete 3 stages of training over the course of 6 months. If you've ever worked for government, like, this is how they do it. They have a probationary period. You have to perform to a certain level to be accepted as a person who can perform that job. Totally makes sense. His probationary period did not go well. According to the department, Smith was far from a model employee. Early in his training, one of his supervisors reported that he challenged the instructions that he was given, which created a serious issue for his training and development. Another supervisor said that Smith regularly failed to remember info and had a very hard time following basic instructions. Particularly troubling, however, was Smith's record of unsafe conduct. Once, while driving in an express lane with Marcelo Vale, one of his supervisors, Smith approached a place where the lanes divided. Vale told him to pick a lane. Instead, Smith stopped short in traffic, only 30 feet from the concrete pillar dividing the lanes. On another occasion, Smith drove away from a gas pump with the nozzle still inserted in the truck. Oh no, Smith, come on, man. Smith also almost hit a troop trooper police car on a drive with a supervisor. Most dangerous of all, Smith ignored instructions to put his truck in neutral and pull the brake, nearly causing a supervisor to be pinned between the tow truck and another vehicle. Incidents like these led one of his supervisors, Lloyd Colbert, to send an email to some of his co-workers warning that if Smith continued to work on the road, someone else will pay the ultimate price. Oh man. Okay. As long as those testimonies can be like trusted. Yeah, those are some pretty serious claims. I mean, those. You can imagine that the employee Smith could possibly get frustrated because of his inability to perform the way that he'd like to, and thus leading to the pinnacle event that we're seeing here. It's also possible that his supervisors get frustrated and do cause a hostile environment instead of saying, hey, you're not right for this job, bud. The department gave Smith negative reviews from beginning, and its assessments... What the heck? Okay. And its assessments of his performance became progressively worse. In a performance evaluation in mid-September, Smith received 2 marks of unsatisfactory. On October, one of Smith's supervisors emailed another saying that Smith was not getting any better and cannot get it. By the end of November, Smith was described as very behind, where he ought to have been at this stage of training. The problems continued into December. Emails between department employees described him as being argumentative, unstable, reckless, unsafe, and in no way ready to go on his own. In January, Smith received another performance evaluation, this one giving him unsatisfactory marks in 5 different categories. Okay, so all of this is exactly how government's going to work. You're going to have a paper trail that leads up to the pinnacle event, which is usually firing. You have to have that paper trail, though. From Smith's perspective, however, the department was the problem. On August 22nd, 2013, he filed an internal complaint with the department asserting that Vale had used abusive language toward him and that another supervisor, Zen McHugh, had threatened to fire him for being confrontational. That same day, Smith wrote a memorandum to his union representative in which he claimed that the department had discriminated against him because he was black and had subjected him to a hostile work environment. In October, Smith sent another memorandum to the department. The subject line was illegally docked hours for my pay, discrimination, and harassment. The memorandum claimed on October 13th, Colbert had told him to sign out 2 hours before he had stopped working, which had the effect of withholding 2 hours of pay from his paycheck. He was eventually compensated for those hours. In December, Smith wrote another memoranda to the department complaining about his treatment. 2 of them, dated for December 5th and 6th, complained that Colbert had denied Smith overtime pay after he responded to a call for assistance with a disabled vehicle late in his shift. He attributed the refusal to racial discrimination, harassment, and retaliation. He submitted 2 more memoranda in late December. He addressed the first with the subject line discrimination retaliation to a supervisor in the department. In it, he claimed that he was being treated differently than a fellow employee who had been allowed to work only 4 hours on a certain day, while Smith had been required to work a full day. The second was also addressed to the department, and it requested a shift change due to discrimination, harassment, and retaliation. Wow. Okay, so he's been laying complaints. It's interesting that they stacked, like, in this, they stacked the reasoning for their decision ahead of his story. But that makes sense a little bit, because Smith is the one suing. Okay. Wow, there's a lot here. I'm not a judge. But I will say that one's also questionable. it's hard because the employer should have, if they didn't, they should have addressed the complaints that he was laying out in a very clear manner. And if they didn't, that's problematic because then they're ignoring it. I feel like there's something we're missing there too. So we're gonna label this one AutoZone, and we're gonna write another one. Voted against. Barrett wrote the unanimous three-judge panel panel opinion affirming summary judgment in the case of Smith versus Illinois. Smith was a black employee. Affirming summary judgment. Okay, so they affirmed that the case was handled properly. Okay. So the district court, he was appealing. District court, I don't want to say voted against. Affirmed district court in racial discrimination. And we're going to label this one Smith, Illinois. Is that who it was? Smith, right? Pretty sure it was Smith. Smith versus Illinois, yep. Okay. Yep. This one was pretty clear, I think. To me, the judgment of that was fair. I'm not a judge, but the judgment seems fair. And I'm going to say that there's a paper trail showing the employees' difficulty to execute the job safely. And I mean, so if you're going to sue the department, you're going to have trouble because the department is not the person. Like, to say that, I think that his argument was misaimed. I feel like if he had sued someone individually, which might not be, you might not be able to do in the case of, like in this case, because if you try and sue that individual, he was acting in his role for the company, or not the company, for the division or whatever it is it's called. So technically, could you sue him personally? I'm not sure. I'm not a lawyer or a judge. I'm just trying to get a feel for what she's worked on. So, control the underline. Let's call this previous cases. Okay, so we've got 3 of the previous cases. There's a few more. She's got like a immigration. We can get a quick feel for these, but we are quickly approaching the 1 hour mark. So with that, we're gonna have to put this on pause until I can get more time. So on immigration, in June 2020, Barrett wrote a 40-page dissent when the majority upheld a preliminary injunction against Trump administration's controversial public charge rule. Let's look at this guy. Under the public charge rule, immigrants to the United States classified as likely or liable to become a public charge may be denied visas or permission to enter the country due to their disabilities or lack of economic resources. Wow. Wow. Whoa. I don't know how I feel about this one. That's a rough one. Public charge rule? Okay. That aside, that's hard for me to swallow. The way that I'm interpreting it now. Barrett wrote a 40-page dissent when majority upheld a preliminary injunction against the Trump, which heightened the standard for obtaining a green card. In her dissent, she argued that any non-citizens who disenrolled any non-citizens who disenrolled from government benefits because of the rule did so due to confusion about the rule itself rather than from its implication, writing that the vast majority of the people subject to the rule are not eligible for government benefits in the first place. On the merits, Barrett departed from her colleagues Wood and Rovner, who held that DHS's interpretation of the provision was unreasonable under Chevron Step 2. Assuming that's not the gas station. Chevron is probably the most cited case in American administrative law. Interesting. But some scholars suggest that the decision has had little impact on the Supreme Court's jurisprudence and merely clarified the court's existing approach. The ruling that the judiciary should defer to a federal agency's interpretation of ambiguous language from congressional legislation relevant to the agency is often referred to the Chevron deference. Okay, so basically kicking it up to the authority. To uphold a preliminary injunction, though, does that mean that she was against this controversial? A preliminary injunction against. And upholding that, what does that mean? I want to see this 40-page dissent. So that's 66A. Cook County versus Wolf. Appeal from the United States District Court for Northern District of Illinois, Eastern Division. Okay, a bunch of people. Like most people, immigrants to the United States would like greater prosperity for themselves and their families. Nonetheless, it can take time to achieve the American dream, and the path is not always smooth. Recognizing this, Congress has chosen to make immigrants eligible for various public benefits. Okay. State and local governments have done the same. Those benefits include subsidized health insurance, supplemental nutritional benefits, and housing assistance. Historically, with limited exceptions, temporary receipt of these supplemental benefits did not jeopardize an immigrant's chances of one day adjusting his status to that of a legal permanent resident or a citizen. Historically, with limited exceptions, temporary receipt of these supplemental benefits did not jeopardize an immigrant's chances of one day adjusting his status to that of a legal permanent resident. Recently, however, the Department of Homeland Security issued a new rule designed to prevent immigrants whom the executive branch deems likely to receive public assistance in any amount at any point in the future from entering the country or adjusting their immigration status. The rule purports to implement the public charge provision in the Immigration and Nationality Act. States, sites, and nonprofit groups across the country have filed suits seeking to overturn the rule. Cook County, Illinois, and the Illinois Coalition for Immigrant and Refugee Rights, Incorporated, brought one of those cases to the Northern District of Illinois. They immediately sought a preliminary injunction against the rule pending the outcome of the litigation. Okay, another word lookup, litigation, just to make sure we know what they mean. I'm going to put that in our definitions. Litigation, the process of taking legal action. It's a good word. Okay. Litigation. Anyways. Finding that the criteria for interim relief were satisfied, the district court granted their motion. We conclude that at least Cook County adequately established its right to bring its claim, and that the district court did not abuse its discretion by granting preliminary injunctive relief. We therefore affirm. Okay, so they're affirming that immigrants should get these benefits in the meantime while this rule is decided. Okay. I think I understand that. Dissent sounds so negative. Is that what I think it means? Dissent, the expression of holding of opinions at variance with those previously commonly or officially held. So she is disagreeing. When the majority upheld a preliminary... Oh my gosh, okay. Upheld. There's just so many positive and negatives here. Confirm or support, okay. So she's disagreeing. Okay. So she's disagreeing with this. With their upholding. Okay, that's a little problematic for me. Mostly just because like because of the rule did so due to confusion about the rule itself rather than from its application. I don't know, I'd be careful here, Amy. Oof. Okay, so worked against immigrants. Worked against helping. This is how I understand it. If this is not the way that it was meant to be understood, please correct me, either through direct message or through the comments section below. But worked against helping immigrants to receive benefits temporarily in a lower status of income. So like if I understand that correctly, basically we're trying to prevent immigrants from receiving help when they're first coming across the border. So basically we're trying to say no, you can't come in here if you're going to cost us money. That's sad. Okay, but this concludes another hour of working towards understanding Amy Coney Barret. She's got a lot about her. We still need to figure out how she manages to balance her life. She's got 7 kids and she's a Supreme Court justice. That's pretty cool. Some of the stuff that she's argued for, I definitely agree with. That first case. That first case was cool because she's basically saying, hey, you were actually wrongly accused, and she fought for the male in that case, which is interesting, considering that she's a woman. So we can kind of make I don't want to make a leaping conclusion, but that she's not gonna be too heavily in the feminism, if that makes sense. So like sex, she's pretty well balanced with whichever sex it is that she's defending or trying to bring justice for. We're definitely going to go into abortion related cases, Second Amendment, criminal procedure, qualified immunity. Here, let me show you. Environment, consumer protection, coronavirus measures. That one's going to be really cool. And civil procedure. Now, obviously, this is a much slower process than I had already expected. I expected to be able to make it through this in maybe a couple hours. It's clearly not the case, and this is probably why a lot of people don't research heavily other people and they choose to slanderize. So I'm hoping that this can become a practice. I need to practice this. I need to get good at it, and I need to be a good example for my son. So with that, I'm going to conclude this session of researching Amy Coney Barret. See you next time. Part 3. Here we come.